Welcome back, ladies and gentlemen. I hope you all enjoyed your lunch. I would now like to have an opportunity to invite our next set of esteemed speakers on stage who will be conducting a session on adapting to India's new space policy, tax and compliance insights, explore how the industry can adapt to India's new space policy, impacting taxation, transfer pricing, financial planning, compliance and international transactions within the space sector. Ladies and gentlemen, please join me in welcoming our session moderator, Ms. Shilpy Chaturvedi, partner Deloitte. Please give a warm round of applause for our panelists joining us on stage, Mr. Kaushik Moitra, partner Bharucha and partners. Welcome, sir. Mr. Arjun Sinha, AP and partners. Mr. Sharath Chandrasekhar, DSK Legal. And last but not the least, Mr. Alaqshendra Singh, KMT Law. Welcome, gentlemen. I would now hand over the dais to our session chair, Ms. Shilpy Chaturvedi. Over to you.
It talks about taxation. I think we can start from there and say that I think tax is one of the biggest concerns as far as a lot of satellite communication companies in this country are concerned. Equally, the requirements that are stringent about having Indians and Indian nationals being there and how it is the residency requirements are there, all that has to be spoken to together. We would all like to see a space policy that before being notified also speaks to the various stakeholders, understands what the requirements are, and then not only talks to space policy but also does the feeder policies, if I may say, whether it's tax, whether it's real estate, whether it's technology, whether it's IP, technology transfer, and only once all that is put under one kind of a unified regime, can you really say that the space policy is ready and here to go, and only then can stakeholders really utilize it.
Just 2 points here. I think on the foreign investment side, it was surprising to see that there were some elements that were presumed to be under the automatic route earlier than became under some sort of a regulated route. While there was enough signals given by the government on how that rule will pan out, it was a little surprising to see there, and that probably shouldn't be the case. I think we should have consistency in FDI. And on the regulatory side, I think, just given our experience on satellites, I think just we're not there yet as a fully investable policy from a foreign investment perspective. The licenses, for example, for some of these are shorter than what the business license needs, so there's a need for a lot of repeat licensing. The need for relicensing has very low threshold, so just mere changing shareholding can create a risk of requiring and applying for a new license. Just changing some technical parameters of your underlying asset can result in a new license. So these are things. Understand the concern of the government where it wants to view and watch and have oversight over what's happening, because it's a sensitive sector, it's a sensitive technology. But the way it's worded, it really does create a lot of investment risk as of now. But it's a good start, and I think there'll be more discussion on and when both sides will get comfort with each other, and we'll have a much more stable policy as we go ahead.
Thank you, sir. Just to add on to the FDI policy bit, right? The way it's been structured and the reason why there are different thresholds to what investments can a specific subsector take is to essentially account for the duality of the least threshold, which is 49% for launch ports and spaceports. It's to essentially ensure that there is a duality between military usage and commercial space activities, and that's something that they need to cater to. But of course, perhaps it does discourage potential investors and stifles the access to global capital and global markets. And as for the NGP, I believe that having a framework which allows an applicant to understand what are the contours of seeking authorization is certainly encouraging. there is the space activities bill which is in pipeline. We expect that will be a much different iteration from what was introduced in 2017. But if the NGP, the Indian Space Policy, of course, and the bill are harmonized, I expect that there will be certainly promising times ahead.
Okay, so a couple of thoughts from my side. I think the ISP and the NGP is definitely a good start. Deregulation in any form is always good. Having said that, I think there are some gaps in terms of, one is harmonization, which both the panelists have already talked about. And the fact that, the policy is just a policy. We have not yet seen the actual legislations, if I can call it that. The reason why I think legislations are more important is because policy is more like a direction, but what we lawyers look at is the law. So we are still awaiting the space activities bill, which has not yet happened. So that is something which we are waiting for. There are gaps in terms of how the regulators have been put in place. You have in space, it's supposed to be autonomous, but it's under Department of Space. Right, so there are all these questions that are still there in terms of gaps. From a purely compliance perspective, just taking on from what Kaushik said, if you really look at compliances for the space sector companies, you're looking at compliances in three buckets. One is the establishment of the entity itself, because you need compliances at that level. Second is like space license and related sort of compliances, which is your approvals from in space, etc., depending on the kind of space that you're in, the kind of activities that you're going to get into. Lastly, and if applicable, FDI and export-import laws, right? And when I say FDI, it is more foreign exchange laws, because you'll also have to see inflow of cash, whether it's FDI or other forms of foreign exchange. Export-import laws is another very important aspect which I think needs to be harmonized, because when we are advising clients, we have to look at it from these three buckets, rather than having to look at it from one pure bucket in terms of this is the kind of compliance you have to do. And also, if you look at the guidelines, there are a lot of places where they said that additional guidelines will come. Now, when we are advising clients, it's a problem. So, while it's a good start, I think there's a lot more that needs to be done, right? And legislations need to come. And I think that's where we'll start getting certainty, and lawyers will be able to give proper legal opinions, right? And make things grow and get more foreign investment into this sector. Because there's just a case in point. There's a particular regulation which basically says that if there's a change in shareholding, right, and you've already got a license from space, they can cancel or amend it. Now, that's going to be a problem when there's foreign investment. Now, what will I do? The way we will change this is basically take a pre-facto approval, rather than get the investment and then, have to deal with the risk. So we have had to deal and start thinking about all these problems, and that's why we are still waiting for more legislation, right? So that's.
Now, and Sharath picked up that thing which is very important actually about legislation. And Sharath, I don't know whether all of you also agree or not. I think as far as the legislation is concerned, while space of itself is a central subject, but there will be multiple things which a space or some communication SATCOM company will require at the state level to actually make India a SATCOM hub. And I'll get to the most rudimentary example, which is land. Right, and we all know that historically projects in India have not taken off because the governments, whether at the center or the state, have fallen short in notifying land years after policies have been notified. I think that's one very important example. Very rudimentary, not space and not fancy, but important.
Like you rightly mentioned about the central and state allocation to happen. or a harmony between those two governments. What do you think the states can do now? Because they can also provide, as you said, the infrastructure for testing, for setting up their offices near maybe an area which may be closer to the testing facilities and everything. What is that the state governments can now do to even get more investors in their state and get more businesses there?
See, I think all the startups which are in this industry, right, I think the first and foremost is that they're looking for SOPs. That's the first thing, right, that a state government can do. So once you're given SOPs, which could be in any form, including land, whatever it is, stamp duty exemptions, we've seen all these kinds of SOPs. SOPs is one. Secondly, I think, as any of these startups, if you really look at it, they want clarity in law and clarity in practice. Now, see, we have these so-called single window clearance systems across India, right? InSpace also is supposed to be one of them. Does it really actually happen all the time? Not all the time. It happens in some cases. In some states it's very good. Some states it's not so good. So these are, and when we talk about single window clearance, the more that is brought into that ambit, I think that will help. Right? And having lesser compliances going forward. I think those aspects, if the state can sort of focus on that, while obviously the center also coming in because the center-state divide. So, but if the state can actually focus on these aspects, and they have, because if they start looking at foreign investment, right, all these states, especially the southern states, because I can talk because I'm from there, there's been a lot of investment in both Karnataka and Andhra, primarily because of a lot of SOPs which were given, single window clearance systems, and the fact that there was a lot of ecosystem which was built for them, for these players. If you see these IT parks outside of Bangalore, the traffic, please leave that aside. That's another topic altogether. But the infrastructure that is there in those buildings is just fabulous. So I think these are things that the state government can do.
So just to add on to what Sharath said, it is absolutely crucial that we leverage on the existing infrastructure. ISRO in space as on date, affords and extends that kind of cooperation and support to NGs, and I think that's really encouraging, and that's something that NGs can leverage on and essentially, initiate advocacy efforts to get those benefits out of the state governments.
Now, this is more from a regulatory front. From a taxation point of view, the basic premise that people worry about is that in space, how do they actually determine the jurisdiction, or how do they, have a common establishment, as we were discussing sometimes back. There is a treaty under the UN which says that space is for everybody's usage, and they need to take care of it as. But there is no demarcation of jurisdiction, there is no demarcation of land and water as we have on the ground. Even there are 20 nautical miles, these kind of things are there when you look at the land level. But in air, how does that happen? And there is, I think, a overlap between 80 kilometer to 100. There is no consensus between how it happens. So where do you think that, how much time, or at least the foreign jurisdiction, how they are looking at these kind of things? Because India is a little 2 steps behind them, and how have they interpreted all these things?
No, I think the only question I actually should have an answer, not a tax expert, but the question we end up getting asked is, whenever you're doing business in India, and especially if you're a foreign entity looking to partner with somebody locally, or you have your own subsidiary in India, tax always throws up the place of effective management question, right? And there are so many interconnected elements in which, especially in space, because the domestic entity often will not have a lot of the technology, or will not even have a lot of the support operations. They will largely be outsourced. And the challenge that often that ends up coming from a practical perspective is some of these rules are probably clearer in some of the jurisdictions they operate, where it's very clear that I'm in my country and I'm providing support services, so I don't have a taxable event. In India, it becomes a little bit more nebulous, and because it becomes nebulous there, usually the tendency is to err towards the side of caution. and therefore do create strict demarcations, maybe do some technology transfer, have the local entity take up some of the responsibilities. But in space, especially when you're looking at foreign players enter India, the tendency will be to centralize, and the tendency will be to have a lot of the operations sort of happen locally, because that's just where the efficiencies lie, that's where the knowledge lies. This is not knowledge that's very easily available or applicable across the world. And that ends up creating a challenge. And I personally foresee tax and tax-related questions to be asked a lot as more and more international space businesses end up setting up shop in India, because companies do what they're comfortable with. It's just that what they're comfortable doing the world over often will result in tax incidences in India, and sort of open up, and we'll probably see more clarity being given, or practice evolve when people get more comfortable in transferring technology and setting up larger operations.
Nothing much to add. I think Arjun covered most of those, most of what I wanted to say. But from an international perspective, I think a lot of best practices from outside India will come into it. I think as the sector grows, and we've seen this in other sectors as well, I think the best practices and what are the practices, they will come in. See, like Deloitte has, establishments across the world. So whatever is happening in, say, US, I think eventually will flow into India as more and more, development happens in this sector. I think that's what we can see. Again, not to help you from a tax perspective, because I don't think there's much help right now. But from a legal perspective, I think some of the things in terms of demarcations that you talked about, I think is already there. Like, for example, the Outer Space Treaty that you just talked about, it's very clear that it's space is for everybody. And space should be for everybody, right? And obviously, when the treaty was done, USA was at its height of its power. And the intent was to set up these satellite systems across the world, right? So there are different intentions with which those treaties are coming. Then the Liability Convention came, right? So that's another convention. But again, I think all of them, there are a lot of established practices. We are way behind on them. But I think they will come into it. It's a matter of time. And I think that's where I think many of us stakeholders will have a role to play with our advice, and while collaborating with the foreign parties as well, whether it's foreign law firms, foreign advisors, whatever it is. But I think we can bring in those best practices. It'll take time. It's a good start. So that's where we take it.
So I do agree with all that has been said. In fact, most of it has been covered. I'll just make 2 points. One from the international standpoint and one from the India standpoint. Right? From the international standpoint, as Sharath said, there already exists a fair amount of clarity which comes with spaces for everybody. People know whose satellite it is. But I think the question that again needs to be answered and will only be answered over time is the fact that in the converged world, one satellite will not remain for one person or one country any longer. Neither will one transponder remain for one person and one person and one country. Equally, just to manage efficiencies, transponders will not only be shared, but just like internet proxies be co-used in a hopping kind of manner. So those are questions that will only come in and emerge once convergence takes place. And they will, fortunately or unfortunately, have to be answered as life goes on. It cannot be answered today. That's on the international part of it, but I think the treaties have really achieved quite a lot, really, and much more than what in other sectors they've been able to achieve. That's one part. And on the domestic, the India part of it, and I know at the cost of repetition, I keep saying this. Sharath has spoken about this. So has Arjun. Tax still remains the one most important piece on whether it's jurisdiction or it's investing in India or otherwise, because for a large number of people who come to us for help, they are simply unable to understand why they are taxed in India, and why they continually will be taxed in India. And our answer to them is, boss, it's just the interpretation of the tax law as it stands in India, and there is no other answer. And I think Shilpy and I were talking about this. There have been multiple stakeholders. It's not very long, but about a decade ago, when there was an exodus, if I may say so, of satellite companies from India purely on the tax part of it. So I think that jurisdiction re-tax is one of the key and most important questions that need to be answered as far as India is concerned. Thank you.
I just want to take the discussion slightly differently, where you talk about convergence. I think to achieve convergence, we will probably need to relook at our licenses right now. We have bundled licenses for services, but as space evolves, we will probably need to look at infrastructure licenses as well, where you can have shared infrastructure, you can have infrastructure only licenses. You don't need to be providing services for Satcom. It really, honestly, to have the only ability to take an infrastructure licenses to actually providing services is not the norm in many places, and maybe we'll have to end up going towards that in India as well.
And absolutely, India already has the examples of common infrastructure sharing. I mean, it was there in FM, it's there in telecom. CTI as a term exists, right? So, I mean, so historically we have precedents. Why not?
The guy who's providing the landing rights to segregate his business from the guy who's providing services, and probably make life a little easier for everybody when they're looking to enter or looking to set up operations.
The ask for make in India or vocal for local. How do you think that the space sector in India, from an infrastructure point of view, from manufacturing point of view, is ready right now to give these, because as Kaushik was mentioning, the technology stays outside of India as of right now. Not much of R&D is happening. But how do you think the manufacturing can support the satellite space in India right now?
I think two trends have happened. One is just because of the whole uncertainty in FDI, even the domestic players have had to look overseas for incorporation. And I hope that trend sort of changes. But on setting up and creating a local ecosystem, I think space is one sector where government has been deliberate and has achieved results. Honestly, we've spoken to people where there's been a lot of active engagement in making sure some of the players sort of that exist today are sort of operational, and they start thinking about it from an early stage. So personally, from a domestic ecosystem building perspective, space is for now a success story. But I think with the whole FDI bit changing, we can probably hope for more re-domiciling of people who come to set up shop. For them, the first advice that they receive from somebody is not to set up an overseas incorporated and overseas holding structure.
If I may. I think to comment on that, right, I think we're doing wonderfully well. I'm sure the room is familiar that Agnikul Cosmos launched Agnivan Sorted not too long ago. And I think that's something to be inspired from. And of course, with the NGP, the authorization guidelines, it specifically caters to NGEs. It creates an ecosystem where they have an ease of access to the market, and I think it's a very promising time.
Yeah, just to pick on, I think it's a very promising time as well, because I think there's a lot of startups, and I've met quite a few of them, and they're very eagerly sort of enthusiastic about making it grow. While there is a lot of technology which is outside India, what I've also seen is that there are a lot of technologies which is in India. So, and the manufacturing is happening in Europe, right? So there's one particular set of people who have the technology inbuilt. I mean, so they haven't, they're building it, they can't build it. So they've had to go to Europe. So I think we do have expertise in a lot of areas. Like, see, from the manufacturing perspective, I think, just purely from a manufacturing sector perspective, I think the last 10 years has been quite good for it. There's been a lot of growth in the manufacturing sector, in all different types of manufacturing. And as he rightly pointed out, Agnikul, has 3D printed right? Which is fabulous. And because when I went to US and talked about it, these guys were shocked, right, in US. So the fact that we have the technology and we're actually doing it is a good sign. Now, from a technology coming from outside India perspective, I think it's going to be linked to FDI in many ways. Pure tech transfers may or may not happen. I believe will not really happen because I think they'll want to come in with the ability to invest. So if you really purely look at it, you have the 49%, 74%, 100% thresholds. So you're going to see growth in these sectors accordingly. So 74%, obviously the 100% automatic route will be on the higher side, right? Your subsystems and all of that. Satellite systems again will be a little bit on the lesser side, and then you come to the launch systems and all of that, right? So I think it's going to be directly linked to what is the FDI threshold and deregulation, especially from linked to the technology side of things. So this keeps coming up in FDI sector quite a bit. I think all of us have grappled with it. There are a couple of ways to do it. See, in some sectors in FDI, it has been made clear that you can maintain separate boards, right, with different businesses. I would not advise it, especially in the space sector. I would not advise it, considering that you have, different sort of businesses with different thresholds. What you would rather do is set up separate entities with a fund, say in Mauritius or Singapore or anything of that sort, which we do quite regularly, and basically get them as multiple different entities, right, with different FDI thresholds, within the threshold, and then again, control is a different ballgame altogether, but keep it distinct is what I would say. I wouldn't say try and mix it up. Where, like for example, one of the interesting questions which has come up is somebody who's in the telecom sector, right, which is 100% automatic. If they want to set up satellites directly, then that's 74%, right? So how do you manage it? So you say set up a different entity. So this kind of structuring has been there for the last, I think, 15, 20 years. It's nothing new. But where it starts getting tricky is that when it starts as a small business, and then suddenly it becomes 40% of your business. And they don't come to the lawyers before, right, or the tax advisor. So there is a challenge, but again, there also you can demerge, you can segregate, you can do all sorts of things. But yeah, I would always advise my clients to keep different businesses which are falling under different sectoral caps separate.
One is obviously the written rule on where the FDI this thing is. Sometimes you may also want to segregate different businesses depending on the nature of clientele you have. And certain clientele you may, even though it's not written, you may want to keep in 100% Indian entity just because the sensitivity is involved and you have licensing arrangements to provide updates and upgrades to technology. So, that's just my feeling that even though it's not written there, that may be a sort of a cautious and a pragmatic way to go ahead.
Just to add there, I think one part is obviously separate thresholds, separate sectors, so separate companies. In a country like India, where there's regulatory, the whole sector in that sense is like a sandbox. We should also possibly think of applying differentiations like what is the platform and what is the technology used, because we do not know as we speak today how the next level of technology or the next level of licensing is going to turn up. So it's very important to make a family of platforms and a family of technology and keep all your technology or similar technology businesses built on the same platform in one place. And then, because then that allows you to deal with foreshadowed changes, which actually, whether in this room or outside, is the biggest issue which we will come up with. What is a foreshadowed change? So I think that's also another thing that we should think about, because as Sharath said, that people will not come to lawyers before they come to a certain critical mass. So while coming to the critical mass, don't come to lawyers, don't come to CAs, don't come to tax advisors, but at least differentiate based on platform and technology so that you're ready when a lawyer or a tax planner comes and tells you that, boss, we need to do this way, you at least can do it.
I think there's a question question from the audience.
Yeah, the question is to Sharath. So when you said that there is another way of, managing different books, if you can just elaborate on that mechanism, though you don't recommend that, you have recommended that for each activities you should have different companies because of the different thresholds. If you can elaborate, this is interesting too.
Okay, so what I was talking about is that in particular different sectors, right, of FDI, the government within the regulations itself has said that you can actually have this business and have two separate books, right? So that those kind of aspects, yes, we say you can do it, but other businesses, okay. So let me take an example. So there was a particular situation where it was 100% automatic in the main business.
So suppose defense,
Mm-hmm.
where it allows 100% for equipments and components,
Mm-hmm.
and suppose space,
Mm-hmm.
and for that particular component, for that particular platform or equipment,
Mhm.
it allows 74%.
Mm-hmm.
In this case, can you?
Sure. So basically, the construct is that if it's 100%, we'll need an approval. Okay.
Yeah, make 40.
174, the example that you gave, if I'm starting the business of the 74% and you're already 100%, you will need an approval. There are no two ways about it. Now, what I have seen in the market as well is that, and let me take this example, there was a particular sector in which it was 100% automatic. There was another sector which these guys were involved in. It was a hospital sector linked to a laboratory and testing, which was under government, but their business size was only 2% of the overall revenue. So we as lawyers actually took a call that it is not important enough that we need a government FDI approval. But if it crosses larger percentages, right? See, what had happened is there was some merger that these guys had done, and that particular sector just fell into the business. There was no foresight on this. When we were doing the due diligence, we found out. Now, for that 1%, do I go to the government?
But it is still the scope of that business of that company.
It's not. So pharmaceutical was not is not in the hospital space, right? So that's why lot of times we take the call, right? And many of it is, as I said, found during due diligence stages, right? But if they come to me on day one, I would say keep it separate.
I think I'll just add to that answer to just have, I think we come back to what I said in the previous question. If we can kind of, as promoters of the company, and I'm talking about promoters of various companies, at the beginning stage when they're not coming to lawyers or tax advisors, at least demarcate basis technology or platform. You can apply it in different ways, right? For example, whether it's a hospital and a lab may or may not be doing pharma. A lab, however, is a lab, right? So it has similar generic technologies used. So as a promoter, that level of evolution has to happen, because otherwise it's very difficult for any lawyer later to say, because that, as he said, will only come up in DD due diligence. Before that, I will not know, but you do know.
I think, thank you all for your time and sharing insights on this topic. And it was great to have this discussion with you. Thank you.
Thank you very much, everyone, for such an outstanding session. It was a fiery chat with all of you. I request you all to please be on the stage, and I request Shilpy ma'am to please present a memento to all panelists, starting with Mr. Kaushik Moitra. Thank you very much, sir. To Mr. Arjun Sinha. Mr. Sharath Chandrasekhar. Thank you very much, sir. And Mr. Alaqshendra Singh. Thank you very much, sir. I request Mr. Rajiv, Senior Director, SIA-INDIA, to please join us on the stage to present a memento to our wonderful moderator, Shilpy ma'am. I request everyone to please be on the stage and please pose for a group photograph as well. Thank you, everyone. Please come forward for a group photograph.